Welcome to the latest edition of the Be Your HR Best webinar. We're coming to you today live from the studios in downtown Tysons for BLC Digital Strategies. Todd Castledy, the president, is at the board today, making us look good. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard, and I also head up the firm's employment law practice.
I'm Kristin Zech. I'm one of our employment law attorneys.
One of our employment law attorneys. No, Kristin handles a ton of stuff. You know, you're too modest. Kristin, great topic today. I've actually really been looking forward to this one. Look, whenever there's federal employment law legislation and regulations, they tend to be pretty consequential. I think this one is going to be one of those. I think this is going to have a real shift within the workplace. So what we're talking about here is the Pregnant Workers Fairness Act, and I know you are going to do the acronyms all day, right?
Well, not really. PWFA is kind of hard to say.
Yeah, I know.
You trip over it. It's not as easy as some of the others.
Well, let's talk about this. So what is the Pregnant Workers Fairness Act?
Basically, this is a federal law that is meant to fill in some of the gaps that have evolved over time. As you know, we've had federal laws throughout history that have protected pregnancy. Title VII, then the Pregnancy Discrimination Act. There are some implications for pregnancy-related conditions coming out of the ACA. But there have been gaps in the coverage. The FMLA doesn't cover a lot of individuals who may be pregnant and may need leave associated with their pregnancy. The PWFA is designed to fill in some of those gaps.
Yeah, that's what a lot of people, this trips them up. I mean, you know, when I first heard about this, I know I was talking to a client about this, and they were saying, well, wait, pregnancy discrimination, that's been on the books forever. And if there's medical impacts, that would be the Americans with Disabilities Act. So why this new legislation? Is this really superfluous? And I think as we go through our discussion today, we're going to see it very much is not superfluous. It very much carves out a whole new realm of protections for pregnant workers in the workplace.
Well, and let's start out with the ADA, because you raise a good point. We have had the ADA on the books for a while. ADA protects any sort of qualifying disability. The problem with pregnancy and the ADA is that pregnancy, the mere condition of being pregnant, is not a qualifying disability under the ADA. So there may be conditions that come out of pregnancy that would have those impairments, such as, preeclampsia, gestational diabetes, something like that. But the mere condition of being pregnant and uncomplicated pregnancy does not qualify for ADA coverage.
Yeah, and I think that surprises a lot of people. I mean, obviously, just the mere physical aspects, I'm saying this as a man, the mere physical aspects of pregnancy, even without some of those extraordinary medical conditions associated with it, it does surprise a lot of people that it does not qualify as a disability. But it doesn't, and so that's why this gap existed, and that's why the PWFA is so critical. So we're very timely today. Today is June 8th. What's important about June 8th with respect to the PWFA?
June 18th.
June 18th. Darn, I'm way behind.
June 18th is the day that the EEOC regulations go into effect. So the law was actually passed last year.
Okay.
But then there was a period of time that was allowed for the EEOC to develop those regulations. They were issued in or about April, and now today they become effective.
So today, as of today, you got to know about this. You got to start taking action. I mean, you probably needed to take action before, but with the regulations really define the law. Kind of lays out the bare bones, especially nowadays the way Congress does things. Pretty bare bones. Executive branch regulations, EEOC, and they received a lot of attention. They got a lot of comments, and as we'll talk about today, they have really put some meat on the bones of this legislation.
Yes, there is. The regulations really add to the text of the law. The text of the law itself is actually fairly short and straightforward, as opposed to the at least 7-page regulation. And once you add the comments in, it's significantly more than that. So
let's talk about, first let's start high level. Who does this apply to? What companies are we even talking about?
So this is going to apply to any company that has 15 or more employees.
Okay, so the same as the Americans with Disabilities Act, same as Title VII, which is where pregnancy discrimination is also housed. So 15 or more employees. And then what about when it comes to employees themselves? Is there any qualifications. We know under the FMLA you have to be there for a full year and work 1,250 hours. Is there any similar qualifiers here?
No, there is no waiting period. So this will apply to any employee who can otherwise meet the requirements of the Act.
Okay, so you hire somebody day one, you find out the next day that they're pregnant. This kicks in, these protections become relevant to those interactions.
Yes, and that is why this is such a big game changer for us.
Okay, and so the crux of this law, it's not like, a pure you're discriminating against somebody because of pregnancy. The real focus of this law is accommodations, right? Like making changes, reasonable changes in the workplace, to help people who are either pregnant, associated with childbirth, or as we'll talk about, the phrase is related medical conditions, which we'll have a great discussion about that. Let's table that for right now. Let's just talk about kind of the mainstream accommodations that the law kind of recognizes, or the regulations recognize, are going to be the types that we're going to see a lot under this law.
I think when you look at the rule and at some of the EEOC's comments coming out of this, the EEOC really intends this to be a fairly straightforward and common sense solution. So the big accommodations that will always be required, allowing extra time for bathroom breaks, allowing time for food and drinks, allowing an employee to have water with them at all times. If you have an employee who stands a lot, giving them a seating ability, somebody who sits a lot.
Kind of like common sense stuff in a way. It's like,
Very common sense.
Yeah.
And the EEOC's perspective on this is that most of these issues really are not going to be a big deal. We might not even need, any sort of medical certification for it. If somebody's pregnant, these are issues that can be resolved very quickly in a conversation with the employer.
How about, okay, so we talked about those things, and I think of those and I'm like, wow, we really needed Congress and the federal government to act on some of those. What about some other things? What about, remote work for a company that is otherwise in the office?
That's a possibility.
Okay.
So it's telework. There's a wide variety of accommodations that employers will now be needing to consider under the PWFA.
Okay. How about reassignment of duties?
Yes. So if we're looking at our classic ADA analysis, we have some significant changes. And I think it's important to note that the PWFA borrows heavily from the ADA and Title VII. But it's not exact, and there's some expansion here, and this is one example. Under the ADA, as you know, typically you don't reassign duties to another employee as a reasonable accommodation, essential duties.
Yeah.
That's not the case with the PWFA. Reassignment of duties is permissible, even hiring a new employee to take on those responsibilities for a period of time can be a reasonable accommodation.
Yeah, so this is interesting because I think it's a mistake for companies out there to just say, oh, this is just ADA, but now we've swooped in pregnancy as one of the qualifying disabilities, because as you've just noted, and I think this deserves maybe further discussion, it is really a drastic departure from the ADA in terms of how you look at things. So let's just maybe recap a little bit. Under the Americans with Disabilities Act, you have to be able to perform the essential functions of a job with or without a reasonable accommodation. But companies, for typical Americans with Disabilities Act, ADA qualifying disabilities, they are not required to change the job. I recall a case one time where it was a quota-related job in the at the patent office, and you had to do so many patent reviews per day. Well, somebody was not able to do that same number. You don't have to necessarily change a quota for purposes of ADA compliance. Here, it's different. Why do you think that they have, what's the rationale behind why under the PWFA that they allow you to kind of make changes in the job?
It's hard to say where that entire rationale is. I think what you see is this concept that the limitations from a pregnancy are limited. There's a finite period of time. We know, generally speaking, a human pregnancy is approximately 40 weeks. It's not going to go much longer than that. So it appears to be the EEOC's perspective that with that finite period of time where you are going to have these limitations, that becomes an acceptable risk for the employer, where you can have these other accommodations coming in.
Yeah. So in other words, you can be an employee and qualify under the PWFA even if you can't perform the essential function of the job, which blows the ADA definition out of the water.
And I think here's what we need to do. So we are working within an ADA framework. We are using the concepts from the ADA, But this is not the ADA. And if you're borrowing what you've learned from the ADA and your experience with the ADA, you really need to reframe it.
Yeah, and as we'll talk about later on in terms of action items by HR and companies, it's not a matter of just saying, oh, now we've got to swoop it in the pregnancy. There's going to be some changes that need to happen in the way they engage in what's called the interactive process. I mean, that's the magic buzzword whenever it comes to either this particular legislation or the ADA. Engaging with the employee, talking about what's a reasonable accommodation. Well, why can't companies just kind of say, yeah, but this is going to be an undue hardship for us? I mean, they do it in the ADA context all the time.
Even in the ADA context, what is an undue hardship is not clear. It's a very fact-specific circumstance. There is no bright line rule that this is undue hardship, this is not.
Yeah.
And I think that's where we are here. I think it's important to pay attention to the final rule from the EEOC, because they call out very specifically items of supposed reasonable accommodation. And when it comes to an undue hardship, I think it becomes more difficult to argue something is an undue hardship when the EEOC has specifically called it out.
Yeah, it still requires a case-by-case analysis, but as you just noted, they do actually list at least 4 separate things that basically, from a common sense perspective, is not going to be an undue hardship. It's going to be a reasonable. I mean, there are things that, to me, I look at it, allowing employees to carry and drink bottled water on the job. I mean, allowing additional restroom breaks, sitting and standing while working, allowing additional food and drink breaks. I mean, you have to be kind of a bad employer to deny any of those in the first place. But you know what? It happens sometimes.
It does.
It probably less in our client base of, a lot of government contractors and IT-related companies. It probably will be more prevalent in manufacturing settings and things of that nature, where shifts are so important and people, leaving their posts really becomes a bit of a problem for the company and their productivity.
And I would put retail into that category,
Oh, that's
too.
true. Perfect, yeah.
But I think, the 4 examples that you've identified, what the EEOC has said is that is essentially a de facto accommodations. You will be required to do that. There should not be really any debate on that. There shouldn't be any, you have to have a discussion, but beyond that, you are expected to do those things at a bare minimum. I think the question that really comes up here is, where do we go from there? Because the rule includes a lot of other examples of accommodations. And that's where we get into this issue of undue hardship. For example, what you were talking about in terms of reassigning essential duties to another employee, or what I had mentioned about needing to hire a third employee to come in and perform those tasks during the pregnancy.
Yeah, the regulations actually give a specific example of a police officer, female police officer who's pregnant and cannot basically perform the essential functions of her job, which would be to be out in the road, be out, like, just performing the job on patrol, exactly. And so in the ADA context, you probably would say, well, look, I don't know what to do. You can't perform the essential functions of what a police job is, being on patrol. Here, under the PWFA, the law basically gives an example in the regulations that says you have to, you actually, it's a reasonable accommodation to assign that police officer to light duty, to desk duty, and I guess that means bring somebody else in to do the patrol duties. That is where it's so different than the ADA.
Well, and I think the question becomes what happens at the end of the protected leave. So when, for example, your patrol officer is able to resume full duties, what do you do with that other employee? Do you now have obligations to them, or do you put them in a different position, or do you, as an employer, just have a bank of temporary employees that you're bringing in?
Yeah, so that's one big issue. Another, I think, interesting aspect of this regulation is it talks about childbirth and pregnancy leave, but then it also says that it covers related medical issues to pregnancy and childbirth. And you and I have had some interesting discussions in the lead up to this podcast as to, like, what does that even mean? So let's talk through some of those. Some have been getting more attention in the press than others for perhaps obvious reasons, but walk through this phrase, related medical issues. The government loves throwing in these catch-all things, and I guess they're sort of a boon to lawyers, but
So let's back up for a second. The actual text of the PWFA does include related medical conditions, but it doesn't identify related medical conditions. It's only really in the EEOC rule that we have this long list, and it's a very long list, but it is not an exhaustive list of potential conditions that may be related to pregnancy. So obviously pregnancy, childbirth, conditions such as gestational diabetes, hyperemesis, things like that you would expect with pregnancy. But then it goes into things that could impact a potential pregnancy. So we're talking IVF.
That's a big one, IVF, yeah.
Any sort of fertility treatments. We are talking about things that would result in the termination of a pregnancy, whether it's by stillbirth, miscarriage, abortion is coming into this. It also talks about hormone fluctuations. It talks about menstruation. It talks about even carpal tunnel syndrome.
Wow. Abortion has been getting a lot of press. Some states sued and said we should not be including abortion under the PWFA. And in fact, there was a late-breaking development. I think it was yesterday afternoon, right?
Yesterday afternoon.
Yeah. What happened?
So, and let me clarify. We're talking about elective abortion procedures here.
Yep.
There appears to be, at least at the moment, some consensus that abortion that would result as a medical treatment for a non-viable pregnancy or something that would threaten the mother's life. That does not seem to be at issue. What is at issue is whether or not an employer needs to provide time off or other accommodations for an employee who chooses an elective abortion. And we really have a split decision right now. We have two cases, one out of the Midwest, one out of Louisiana. The one out of the Midwest, essentially, the court said, dismissed the challenge, saying that the EEOC rule was perfectly permissible and allows it to go into effect. The Louisiana court took a different position on this, and the Louisiana case involves challenges from states as well as the U.S. Conference of Catholic Bishops with respect to both whether or not the state laws that prohibit abortion in large or almost total part are impacted by this regulation, and then obviously with the Catholic bishops whether or not there are religious components to this.
Yeah, so that's still to be determined, but it's a controversial aspect of it, and what it goes to is what we talked about before, how broad they have taken this concept of related medical issues, and frankly, it hasn't probably even started yet, because you can even look, you said that you believe that the Pregnant Worker Fairness Act could be applied to men, and you kind of blew my mind there, and you had a great explanation as to why. Please say.
Sure. So when we look at this idea of a potential pregnancy, particularly when we're looking at some sort of fertility treatments, I can see a situation where you have a spouse or a partner of an employee, and well, let me rephrase that. If you have an individual who's going to carry the pregnancy or who is contemplated to carry the pregnancy, and their partner is participating in that fertility treatment, be it male, female, or otherwise, I can see a situation where for that partner, as the employer of that partner, you may have obligations under the PWFA to provide time off for fertility treatments because it's related to a potential pregnancy.
Makes sense, yeah. Okay, so this federal law, I mean, again, I said it at the very beginning, I think it will create a lot of changes in the workplace. I think it'll be a lot more seismic than we think. I think it's just not a pure discrimination type outlaw. This is very much a mechanics-driven legislation now that we've seen the regulations. So that's on the federal side. What about on the state side? Because as we know nowadays, I mean, employment law and HR leaders out there, you all live this every day with so many different things: pay transparency, non-compete, restrictive covenants. The states are driving a lot of this, and the states have been somewhat active in this area already, even before the feds just passed this. Talk about that a little bit.
So many states, in fact, all of the states within the DMV or jurisdictions within the DMV have had pregnancy and lactation-related protections on the books for a while. And in part, that happened because the federal legislation did have those gaps that we discussed about initially.
Yeah.
So the PWFA will interface with those laws. Certainly, if there are state laws that are more protective than the PWFA, then you are still bound by those state laws. I don't see this as necessarily changing those existing laws. Many of you are already complying with them because they've been on the books for a while. But it is important to keep that in mind, particularly if you're working in multiple jurisdictions.
Yeah, you've got to know. I mean, and rare is our client base. Rarely are they just operating in one. You know, gone are the days where it's like, oh, our company's located in Virginia and all our employees report to a Virginia office. I mean, that just doesn't happen anymore. The nature of government contracts doesn't allow it. The nature of just workplaces in general with remote work, particularly coming out of COVID. So we're not certainly going to spend our time schooling the folks today listening on the finer points of each one of these states. But you do have to know both the federal and the state. You can't just say, well, I'm going to pick the federal one and I'll just comply with that. I mean, the states, so for instance, Virginia kicks in at between 4 and 15 employees. And we know the new federal law kicks in at 15 or more employees. And so you've just got to be able to know these nuances. That's just one little nuance. And then they do different things. So the federal law sets the floor, basically. But if there are more stringent state laws, then you have to also comply with the state law. If there's less strict or less protective state laws, you've got to make it all the way up to that new federal law, because that sets the floor now. It doesn't replace, it just sets the floor.
That's correct. And again, I mean, this is a situation employers have found themselves in for years now with respect to sort of the patchwork of state laws that have developed on any number of topics.
Yeah. We have questions coming in as we're talking, and I want to get to one of these right now. So here's the question that somebody wrote in. How should we handle a situation where an employee's pregnancy-related accommodations actually impact their productivity? Like, I mean, if you're hired to do a job, and you can't do the job, and let's just say you can't do it for 40 weeks, like what's a company to do? What's a company that has, let's say, 15 employees right at the cusp of being protected? I mean, each person there is critical to the success and the ongoing viability of the company. How should they handle something like that?
They should call their lawyer. And I say that, but it's true, because again, when we're looking at an undue hardship, which is where this is going, is we have to look at what is the nature of the company right now, what's the financial implication, what is the work-related implication, because if I look at just the EEOC regs at this point, then options for this would be to hire another employee to take over these responsibilities, to shift them to someone else, to just not have them done for however long this is going to last. So that's when we really have to shift to that hardship analysis and figuring out whether or not this is truly something that we cannot handle.
Like if somebody comes to you, let's just say in the same example, and says, I have postpartum depression, you can't really just say, and because of that, I want 4 weeks of leave. I mean, it doesn't, unfortunately, mental health doesn't work that way. And so you're asking for indefinite leave, so that presents a problem, because that kind of, we talked earlier about the fact that they look at this as temporary, and somebody will be able to resume their essential functions in the near future. But postpartum depression, we know, would fall under this protection. How would you be handling a situation if you were presented with that?
So I think the first step I would look is postpartum depression is going to be a qualifying disability under the ADA. So I think I would come back to that. And what the ADA says is that indefinite leave is not permissible. Now, typically, I would expect that a physician certification or a midwife certification on postpartum depression would be incremental. I would not expect a total removal from work for an indefinite period of time. But there would be periods of time where you would renew it. And what the ADA says about leave like that is, there's not a bright line rule. There's some period of time where it becomes unreasonable. 2 weeks is probably not it. 1 month, maybe, depending upon your circumstances. The longer that leave period goes, the more we become concerned that it becomes an undue hardship. I think with respect to the PWFA specifically, this contemplates that whatever that limitation is going to be is of a temporary nature. Arguably, when we look at postpartum depression, to your point, there may be some indefinite nature to it, but this is still looking at temporary. The problem is when we look at the regs, the example they give is pregnancy, which again is 40 weeks. Talking almost 9 months, which well exceeds what we would look at under the ADA. That would be out. That would be pretty much. I would be pretty comfortable that would be considered unreasonable, too much of an undue hardship. I mean, unless you're a huge company where you can absorb one person going away for that period of time. Right, but with a 15-person company, that becomes very difficult to remove somebody completely from the workplace for a 9-month period. The short answer to your question is we don't know entirely how that's going to play out, but you can see that all of these laws are still impacting and still effective, but we need to figure out how to navigate through them.
Yeah, and I think companies really have to take to heart this notion of interaction, and this case-by-case aspect. So, for instance, in a case like that, where if you got an email from an employee saying, I have sadly postpartum depression and I need indefinite leave, I don't think an employer can just put their head in the sand and say, oh, you just triggered the words indefinite leave, you're done, sorry, that's per se unreasonable and that's an undue hardship and we're not going to grant it. I think they really have to have a lot more good faith going into it and say, well, okay, first off, so sorry to hear that. Can you get me a little bit more guidance? For instance, when is your next eval, psychological eval, such that maybe then that will provide us a more definite window as to when this leave. You know what I mean? We can't just do bright line rules. It's got to be interactive. It's got to be case by case.
And even though the PWFA is a little bit more expansive in its current form, there is still an ability to get certification from a medical provider for what is going on here.
Let's talk about that, because under the Americans with Disabilities Act, there is some robust procedures for companies to find out, more about like what this disability is, and they can request more specific documentation from medical providers. In some sort of circumstances, they can get a second certification if they pay for it and stuff like that. I find that most don't go down that road, and
Usually it's not necessary.
I really don't encourage it anyways. You're starting to play a little bit of a doctor in that situation.
Yeah.
But so the PWFA changes once again the ADA when it comes to medical certification. Talk about that a little bit.
It does. So let's be clear. The PWFA still allows certification to establish what the condition is, to establish that it's related to pregnancy or any related condition.
Unless it's obvious.
Well,
like if somebody,
We'll get to the obvious in just a moment.
Okay.
Here, because I think that kind of goes to the reason that we have the PWFA. And then the third component of the certification is, what is it that you employee need?
Yeah.
Again, what the EEOC has said is that this is primarily designed to resolve issues that are obvious. It's never a good idea to ask somebody if they're pregnant, under no circumstances.
Yes.
Yet at the same point, what the PWFA, or excuse me, what the regs are essentially saying is, look, if it's obvious that someone's pregnant, you really shouldn't ask them for certifications if they need to take more bathroom breaks.
Yeah.
So we have this sort of back and forth on this issue.
Yeah, it sounds like what they've done is they've said, listen, the nature of what we're talking about here, pregnancy and related conditions, IVF. I mean, these are topics that are very private to people. And so unlike, you did mention carpal tunnel syndrome, but unlike that under the ADA, where it's kind of like, okay, people don't really care too much that they share. I mean, they can share stuff about their wrist injuries and stuff like that. This is just of a much more sensitive and private nature. And so what they wanted to do is be a lot more guarded. They did not want employers fishing around about certain things related to people's reproduction and things like that. And so I think that's why they struck this balance of saying, look, you can get some things are going to be obvious and you should not be asking for medical documentation. For those that are not, you can ask for it, but you're not going to get a treasure trove of medical records. You're going to get confirmation records, which I would think are going to be more of a summary basis of things, as opposed to, a whole long listing of IVF treatment, which, nobody wants to pry into that.
I think you're right. And again, I think that there is a design here to be attentive to how sensitive this may be. I think, again, it is difficult to look at somebody and say, obviously, this person's pregnant or this person's not. What I think the EEOC, and actually what I think Congress is trying to do here, is to have address those circumstances that are just obvious situations where you have, somebody who is 7, 8, 9 months pregnant and they're standing all day long, or they don't have time to go to the bathroom, or they're not allowed to have food.
Yeah.
Those are the circumstances that I think were really at the heart of trying to address this.
Got it. Let's see. A couple other questions. Should my company track requests for accommodation and what the final decision is?
So I have a mixed view on that.
Okay.
I think when we talk about the 4 basic accommodations that are always permitted, so the bathroom breaks, the food, water breaks, the sitting, standing, the water, I don't really see much need to track
agree.
that. But
Yeah.
I do think if we're going into an accommodation that is something else, that is
Remote work, something, yeah.
some sort of reassignment of responsibilities, then I do think I would follow the same same interactive process that you would do under the ADA in terms of what is requested. Is this reasonable? Can we accommodate it? Can we not?
Yeah, and what it will help to do is it will help to create a level of consistency. I've always said that when you're doing these accommodations, there should be a centralized system. It should not be up to individual managers across a company to decide whether or not their subordinates should get a particular accommodation, because they should be involved in the process. There's no doubt about it. But if you start to have inconsistency among management, this should be something that should be directed by HR and upper management, because what happens is one frontline manager might say, I'm not allowing telework because I just want you here. I want you to be at the office. I feel like the team plays better when you're all together. And then another one says, that's no problem at all. Well, guess what? You really, as a company, have just destroyed any argument of undue hardship, because, you've shown that some people can telework. And the fact that you're inconsistent, I think, really sends a mixed signal and is a mistake.
Anytime you have an employment issue, you should be running it through HR. Even if HR is a sounding board, it gives HR the ability to help determine how to interact with the employee and also to develop these consistent results.
Yeah. So the FMLA, the Family and Medical Leave Act, isn't that already a law that kind of deals with a lot of this stuff? We talked about that there was a gap earlier, but doesn't that also provide leave and things of that nature for childbirth related conditions?
So the FMLA does. It provides leave for physical conditions related to childbirth. It also provides, serious medical conditions. It also provides leave for bonding with a new child, whether adopted or birth child.
That's different, though, bonding, right? That
is. But remember, the FMLA only applies to employers who have over 50 employees, or in some cases, 50 employees within 75 miles. So not everybody is subject to the FMLA or able to take advantage of the unpaid leave that it offers.
Yeah.
I think that's where the PWFA perhaps is one of the biggest changes that employers need to keep in mind. Because under the PWFA, somebody would be entitled to leave to recover from childbirth. So that leave is 6 weeks for an uncomplicated vaginal delivery, 8 weeks for an uncomplicated C-section. It can go up from there.
Yeah.
Essentially, what's happening is that employers who are subject to the PWFA but who may not be FMLA subject should be considering these extended leave periods.
So if you're in between 15 employees and 49 employees, so you're not quite at the FMLA one, you can't just sort of say, well, no, we don't have to provide any kind of leave for any of these medical conditions. Now we may very well have to, under the PWFA, we may very well have to provide leave for this. So
absolutely.
Yeah. How about so there's just so much going on, and I think it's a very good thing. So much going on in the workplace and these rules related to protections for mothers to be and new mothers. The Federal Pump Act.
Sure.
I think it's worth mentioning that too, because there's a lot of interplay between all of that. Talk about that just a little bit, just to make sure we've got the full library of all the laws that would come into play.
I think we need to look back at why we end up with the Federal Pump Act.
Because let's talk about what it is. Yeah.
For the longest time, lactation was not necessarily considered a pregnancy-related condition. This was the problem with Title VII and pregnancy. Pregnancy ends at the delivery of the baby.
Yeah.
Therefore, lactation really is not related to pregnancy. So there was really no federal protection for breastfeeding in the workplace at all. The ACA comes along, and there is a provision in there that's drafted in conjunction with the FLSA that provides some protections, but it only provided protections for employees who were classified as non-exempt. So then you ended up with a large portion of the workplace who may be lactating, but were not covered under the laws.
Yeah.
That's what really precipitates the Pump Act in terms of covering everybody, to ensure that employees who are lactating are able to take the breaks that they need, are able to have a safe and clean environment, a private environment in which to pump, are able to have access to a refrigerator in order to keep the milk cool.
Yeah, I mean, we've heard horror stories. I mean, not too long ago, a decade or so ago, where really it's go into the the bathroom.
Right.
Go into the ladies' room, and if you need a pump, go into the ladies' room. And I think this came about as kind of that's crazy. That is absolutely crazy. So companies need to be aware of that too. The refrigeration's an important part of that. Just having a shielded space. Certainly not just the ladies' room. That's
no. And I think the other thing to keep in mind too is even beyond the Pump Act and the protections that you've just mentioned, there are lactation-related conditions that are protected under the PWFA. So situations where somebody has low milk supply or other conditions that could affect their ability to breastfeed in some capacity, there may be additional accommodations beyond what the Pump Act provides.
We've got another question. Okay, how do we determine when a request for accommodation that would be denied under ADA guidelines due to undue hardship, like the reassignment of duties, could be a reasonable request under the PWFA? Okay, we've touched on this a bit, but it is true. You're almost having to have two different tests, within the HR department, and then conveying those out to management is a whole separate challenge.
And I think that's another reason why you should be consulting your HR department when you have these situations, because HR is really going to be in the better position to navigate this. Look, when we're looking at undue hardship, there are a number of factors we have to look at. We have to look at the financial aspect. We have to look at the impact on the workplace. We have to look at the feasibility of something and whether or not this is going to work or not work. For example, this idea that's posed in the regulations about hiring another employee to take on these responsibilities. In some cases, that may make sense. In others, that's just not going to be feasible at all for the company.
Yeah.
So it really does become a case-by-case analysis on undue hardship.
Yeah, and a lot of our clients are government contractors. A lot of them, if they're time and materials, they've got billable slots that they have to fill, and just having especially in the more highly skilled technical cybersecurity things, AI type work. You can't just take somebody and plug them in. It's not feasible. No, who's going to take that job for 4 months, 3 months, whatever? So it is a conundrum for them, I think. But it's one that the law is clear, so there's no getting around that. So they're going to have to face this head on.
And I think the law is also clear that financial obligations alone are not the answer to undue hardship.
Yeah.
So even if it's going to cost money, that may not be the complete answer on whether or not it's undue.
What if you can't fill that job because, as I just described, it's impossible? It would be impossible to find. Would it be? And again, I'm throwing this out there just as a thought. Could you argue as a government contractor that not filling that slot is a breach of their contract with either their prime or their agency client? And would that be potentially an undue hardship?
Potentially, and that's something that we'd have to consider based upon the contracts that are at issue.
Yeah.
The reality is, if you have an employee who's not able to perform those responsibilities because of their pregnancy or whatever that related condition is, there's an open space, and that in and of itself may be a violation.
Yeah, so these are not easy issues. I don't raise these to say here's the right answer. These are the things that HR departments are going to be grappling with. So it's not easy at all. Okay, we'll probably be finishing a little bit early today, but we're getting towards the end, and I always like to end with what should companies be doing now to implement this PWFA in their workplace.
So I think the first thing HR should be doing is making sure that they understand the differences in these laws and how they all interface. And then I think there's training that goes down to the managers. In particular, what these new regs contemplate is that some of these very, very basic and fundamental accommodations are going to be granted without really any discussion. And managers need to understand that. You shouldn't be stopping somebody who is pregnant from taking bathroom breaks. That needs to be permitted. They have to be allowed to have water with them. That should not be the issue. So I think it is training employees and managers and making sure they know what their obligations may be. With respect to policies, look, it's always good to revisit your employment policies on a regular basis, particularly if you're working in multiple jurisdictions and with the changes that come. I don't know that this necessarily changes some of the provisions on pregnancy discrimination that we often see in handbooks. Most of the handbooks we typically look at will say, we're not going to discriminate on the basis of pregnancy. I think where it comes down to is how that is implemented and what may be permitted. Yeah,
I almost think, and again, this is up for reasonable debate, I almost think you have to have, if you do set forth your accommodation process in, let's say, your employee handbook, I almost think you might have to have 2 accommodation processes, and not just rely on a one-size-fits-all, so that you can convey to the workforce, like, here's how we're handling ADA accommodations, here's how we're handling pregnancy, childbirth, and related medical condition accommodations. I think that's important. I think it's hard to do too much in a handbook. We always espouse, don't try to do too much. You're not, but where I do think is, you touched on training. I think written policies and training, most importantly to your frontline managers as they're looking at this stuff, because they're the ones that are going to influence, because my example of the government contractor where you can't fill a contract, well, that manager is not going to be happy with that situation. And they're going to try to influence a decision of, listen, we've got to let this employee go, or we just can't accommodate here. And I think that's where HR's got to do the right training, both in written policies that lay this out for managers on how they handle this, as well as, actual in-person or live training, I should say, to kind of go through some of these issues, so that managers are aware that this is a lot more delicate and a lot more intricate than just oh, this is going to make my life a little bit hard, for a short period of time.
I think it's important, and we always say this, for managers to understand how the story plays out.
Yeah.
Managers often see one component in their day-to-day interactions with the employee. HR, though, as you know, is often looking on a broader basis in terms of how to keep the company out of legal trouble. And
Yeah.
it's important to see how this story ends. I think, from my perspective, if I'm advising an employer on a handbook, if somebody has a situation involving pregnancy or a related condition, I want them coming to HR, because HR, we are then in a better position to determine, are there obligations under the ADA? Are there obligations under PWFA? Where does this fall? And walking the employee through that process.
Yeah, it's going to be an important thing for HR to coordinate with management. I always say, does anybody really want to be on the receiving end of a lawsuit in front of a jury? I don't care where that jury is, and I don't care what the makeup of that jury is. When it comes to somebody, a pregnant employee or somebody going through some of these issues, postpartum depression, stuff like that, and to find that the company really, really phoned it in, didn't engage in the interactive process, really try to say, well, we did it over here, we denied it over here, so we're gonna fall on the sort of consistency and deny it over here. I think those are some of the toughest cases to put in front of a jury. I think the sympathy factors for a plaintiff is overwhelming, and I think if you want to test that as a company and see how mad a jury can get and potentially award punitive damages and things of that nature, then I wouldn't want to be in those shoes. And I know that when we advise our clients, we definitely, when it comes to pregnancy issues, there's a particular sensitivity, as there is with all discrimination, but those ones seem to really, really resonate in front of juries.
There is a wealth of cases out there, which you alluded to already, of things that have happened with respect to pregnant employees or lactating employees, and they don't fare well.
No. People can identify very quickly with that, and like I said, the sympathy factor is real high. Well, listen, I'm glad we had this good discussion. Hopefully people know, again, today, people who are watching this on tape, it's June 18th. It's not June 8th. June 18th, this all goes into effect. You got to know about it, and you can't just say, oh, I read an article on Sherm about it. You've got to implement this. You've got to act on this. That's the best way, and I know that's probably taking this first step of watching this is a good way to do that. So, Kristin, great discussion. Thank you for all that you've offered in here and all your insights and everything like that. So, thank you, everybody, for joining us either live on this webinar or who is watching this, and stay tuned. We do these on a quarterly basis, I think. Be your HR best, so stay tuned for the next one. Thank you, everyone.
Thank you.